Name's Bryan Harris. I'm an attorney with the Public Defender's Office. I'm currently in the post-conviction unit or the recidivism reduction unit in our office. I generally do the majority of our expungements, which are the motions to have your charges dismissed and not guilty plea entered and then have the charge dismissed. That also includes things like 17B motions, which is reducing felonies to misdemeanors, certificates of rehabilitation and pardon. Basically, to understand the change that AB 731 or AB 731 does, you have to understand basic expungement rules. And in order to have a felony expunged in California, there are basically some requirements you need to have to be eligible for it. And the first one, you have to be completing your sentence and you have to be done with your probation. You can't have any pending cases. And most importantly, you couldn't have gone to state prison on that case. So if you did go to state prison, you up until now, you weren't able to get your felony expunged. There's an exception to that, which is 1203.41, which deals with AB 109, which is basically just a realignment of what the sentences are. And what that says, if you were sentenced after 2011 to a felony and you were sentenced to jail prison, which means you were given prison time, but you served it locally, and then you were put on something called mandatory supervision, you would qualify for, be eligible for relief under 1203.4 and get it expunged. That still left out a good portion of felons who were sentenced to prison on their case, state prison. And if you spent a day in state prison, you weren't to be eligible for expungement. Now, with this new law that goes into effect basically July 1st, if you were convicted of a felony and you've served your sentence and you went to state prison, you are eligible for relief if you don't have any cases pending and you've stayed out of trouble for 4 years. Now, there's some exceptions to this. If it is a crime for which you have to be a registered sex offender, you're not eligible for this relief. There are certain serious and violent felonies that it doesn't appear that you'd be eligible for relief. However, given the way 1203.4 motions have gone in the past, that may be something that's left to the discretion of the judge. Basically, you're going to plead your case, show what you were convicted of, what you've done in the meantime since then to show that in the interest of justice, you're deserving of this relief. So basically, that's what it does. It allows people who went to prison who previously weren't eligible for relief under 1203.4 to now become eligible. And it's pretty much a game changer for anybody who went to prison not on a serious or violent felony conviction. And the wording of it makes it seem like it's much more automatic than a regular 1203.4 motion. The motions, the way they used to be, were solely up to the province of the judge, whether the judge wants to grant it or not. This seems like it's almost automatic. If you meet the eligibility requirements, you should be able to get this relief. And that's the main difference. There's other things that it does. It talks about how employers aren't going to be able to access your criminal record aren't going to be able to access your criminal record as easily as they did in the past. It does still allow access to cases which were expunged by teaching credentialing boards and local police, but not to anybody else. So if you do get this relief and you do get it expunged, you can be pretty sure, unless it's a public agency, that nobody's going to see your convictions. And basically that's it in a nutshell. if you have any questions or specific, not sure how specific you want me to go into this, or if I'm being too technical with the wording.
No, I think it's great, Bryan. I was going to say, if you could just like maybe share about if you know like how people then would be able to apply for it if they have to apply for it, or like how the public defender could help support people in getting their stuff off.
There are certain things that are automatic, and there's one of them is getting an arrest seal. Basically, what that means is if you were arrested and no charges were ever filed against you, that arrest is still on your record. But now, under new law, it gets automatically wiped out, which means if you've stayed out of trouble for 4 years after, or 3 years after the arrest and nothing's happened, it automatically happens. You don't have to do anything. It just gets wiped from your record. That's also true if you were arrested, went to trial, and the case was dismissed, or you were found not guilty. That automatically gets wiped clean after a set amount of time, which I believe is 3 years. The only time it doesn't happen is if it's a crime where there's no statute of limitations, like murder, something like that, because they could be able to refile that at any time. With expungements, though, you have to take action in order to get this relief. So what I advise people in Orange County to do is go to our website, Orange County Public Defender, and there's a link on it called New Leaf Program, which is the program I work for. And it will have a form you could fill out, an application you could fill out asking for relief. And basically, you don't even need to know what type of relief you're going to try to go under, the 1203.4, 1203.41, or this new edition that we're talking about from SB731. You fill out the questionnaire, an attorney will be assigned to that case. They'll go over the eligibility requirements and work with you on getting the relief that that you're eligible for. And basically, my paralegal would contact you. You'd go over the questionnaire, basically just asking about your criminal history, ask you to write a little bit about what you've done in your life in case we need the judge to consider something you're deserving of this relief by, in the interest of justice. Maybe a couple letters from friends, employers, or family members speaking to your good character, and we'll draft that motion, file it, and it should be heard within a month or two. And basically, that's all you have to do. We take it from there. We get the DOJ report and check out your criminal history and see what else we can do with regard to your record. In Orange County, or Orange County Public Defender's Office, we can only handle Orange County. But if you look on the websites of just about any public defender's office in California, they're going to have a similar program to the one we have here. And it's similar means of relief. And it's free.
Bryan, for those that aren't familiar with the process, I've been in this a long time, so I definitely know you guys' website. It's a great website. But what convictions then do you guys handle as far as like location, where it happened, if somebody's living in Orange County, but it happened somewhere else? Can you tell them a little bit more about that process?
Yeah, we handle convictions out of Orange County. So it has to be originated in Orange County or transferred to Orange County, meaning that you had to have been arrested, tried and convicted, or pled guilty in Orange County for Orange County to handle it. If you were arrested in Riverside County, you'd have to go to the Riverside County Public Defender's Office, even if you didn't live there.
Anybody else have any questions for Bryan or the process? Or so I know you said it took about like a month or two for the kind of to be heard and whatnot. What's like the full like turnaround time that somebody could expect to get something like off their record?
Ideally, it would be 2 to 3 months. The main log jam is basically me. I'm the one who does all the motions, so I need to do it, prepare these motions when I'm not in court. And the more motions I do, the more time I have to spend in court. So it's kind of a catch-22. Usually, ideally, it'd be 2 months in order for us to get the Department of Justice report, make your file, prepare the declaration, prepare the motion, and then serve it. Then you got to give the DA at least 15 days to respond. The clerks in our county usually make us wait about a month before, from our filing to the time it's placed on calendar.
And since they're all like service providers in the room, if anybody say they're working with a client and like they have a question or follow up or anything, like where could we refer? Do we refer them to you? Do we refer them to just call on the web, go on the website, call? Like what would you recommend for somebody to follow up for their client?
I would recommend, number one, the website. Of course, if any of you guys have questions, you can call me directly. I prefer that you do it as opposed to my number just being out there, my direct line just being out there. Yeah, the website basically it answers any and all questions you would have with regard to whether or not you're eligible, and if you aren't eligible, what other steps we could take. Because basically what this new law does is it makes almost everybody eligible, and at least eligible to apply. It used to be I'd have no answer for somebody who was convicted of a felony and at some point went to prison, other than say you don't qualify for relief. We have the only relief you're eligible for is a certificate of rehabilitation and pardon, and that doesn't really clear anything. It just somebody saying you're rehabilitated. So we're going to have a flood of new cases coming as of July 1st. And I don't think most people have even heard of it yet, given that I did an event 3 weeks ago and people were asking me about it. I didn't even know that this law had been passed. So once it gets out there, this is going to be big.
Yeah, I was going to say that the irony of that statement is I was actually one of the ones that went up to advocate for this back in, I think it was like 2018, 2019. We all went up to Sacramento to advocate for these laws. And fast forward, I wasn't even aware of it. And I think actually Anthony, who's on the call, Anthony had messaged me about the 731. I was like, I don't even know what that is. I'll look into it. I didn't realize the name of it and that it had officially passed. So yeah, we're those of us who were even involved may not even know that it was officially passed. So so I definitely think it's going to be good news to get out to people. For those that then don't qualify, so for those that do have a serious violent felony or like a 290, is there any reprieve for them, or they still have to like kind of apply for pardons, or like what would that look like?
Yeah, the sex offenses, if you're required to register, you're not eligible for relief under this section. The only relief you'd possibly be able to get would be a certificate of rehab and pardon. And you can, and all that's available on our New Leaf website as well. The serious and violent felonies, it's kind of vague how it's laid out in the bill with regard to who's eligible and who's not, or as to whether or not a judge could find basically an assault with a deadly weapon, which is a serious and violent felony, would be eligible for relief if the person went to state prison. If they didn't go to state prison, they'd be eligible for under 1203.4. Under this new section, it appears that they may be eligible for relief, but it would be in the interest of justice. So it's not one of those automatic, you file the petition, it's going to be granted if you check all the boxes. So I would suggest anybody who has any offense short of murder, even, I mean, try to look into this this relief, because it's not going to hurt you asking for it.
Bryan, you're about to become real popular in Orange County.
I have a question for Bryan.
Sure.
So it sounds like if there is some type of violence involved, a gun or whatever, it sounds like in order to get this, to figure it out, whatever, they're probably going to have to go before a judge. It sounds like, right? They're going to have to go to court and go before the judge.
Yes, yes. They'd schedule a hearing date and we'd appear.
Yeah.
And the beauty of what we do, because it's post-conviction, is if you can make it, great. If you can't, I can appear on their behalf. You just got to set it up.
Got it. Thank you.
No problem.
Bryan, I was wondering if you could share, or if you're familiar with this part too, because I know this is a common misconception. In fact, I was just helping a client last night with it. So once something is dismissed, expunged, whatever, off their record, can you share with everybody how it still shows up on their record?
Yeah. Basically what it does is, if you've ever seen a DOJ RAP report, it's got several citations that are repeated through the RAP sheet. So if you're arrested in 2011 for a DUI, it will say DUI arrest, the charges 23-152A, 23-152B. And then if a warrant was issued on that, it will show up again. It'll say warrant 23-152A, 23-152B, and the date that the warrant issued. Then it'll also show the court date. And it'll say court, and then it'll say 23-152A, 23-152B, the court case number, and then the disposition. And the disposition usually says, I mean, if you pled guilty or were found guilty, say convicted, 3 years probation, fines, fees, and whatever. What the expungement does is it doesn't erase all of those notations. Your arrest is still there. A warrant, if it ever happened, was still there. But the court, in that place, it will say the charges, 23-152A, 23-152B, and then disposition, instead of saying convicted or guilty, it will remove that. It will say pled not guilty, and then dismissed pursuant to 1203.4. So that's what they'll see. Certain misdemeanor, but hang on, with new legislation, certain misdemeanors are gonna be wiped from your record. And that's not S731. That's another bill that just came through. After a certain number of years, misdemeanors are just going to be erased. Arrests are still going to show up, but under Penal Code 831, I believe. Those are going to be sealed automatically too. So what you're seeing now is it's going to show the charges, but it will show that it was dismissed under Penal Code Section 1203.4. And what that means is you're relieved of all the burdens or consequences of that conviction. One thing 1203.4 relief doesn't provide you, though, is restoration of gun rights. So if you're convicted of a felony in California and your gun rights are taken away, getting this case expunged doesn't reactivate your gun rights. And basically, that's the only right I know that you lose as a result, and that you cannot get back from 1203.4. Like the right to vote, everybody in California has a right to vote unless they're in prison. So no matter what you're convicted of.
Any other questions for anybody, or anybody have any other questions? Fred?
Yeah, I have another question that just came up. So realistically, if somebody went through that process and then they went to apply for a job and they have a background check done, and these things still show up as you indicate, except with the that it says dismissed. Realistically, what do you think the odds of that employer saying, well, this person still has there's still been some issues with this person? Or is that language really going to make that big of a difference to an employer? I don't know if you know the answer to that, but
Well,
I'm
here,
just throwing that question out there.
the thing I get from most of my clients is, I got the job and I was hired. They didn't ask me about my criminal history when I was hired. Then once they get the job, because under California law, I don't think they're allowed to ask. If you have 5 or more employees, they're not allowed to ask until they've given you a tentative offer. So they give you the job. Then once you're at the job, they do the background check and they say, sorry, we're going to have to let you go. Company policy doesn't allow us to hire anybody with a whatever drug conviction or a robbery conviction. I think that the relief we're talking about, the 1203.4 relief we're talking about is worthwhile in that phase, because it's not that the employers don't want to give you the job, it's that their guidelines don't allow them to. And this, although it's a technicality, for all intents and purposes, they don't have that conviction and should be able to keep that job. I hope that answered your.
Yeah, and I was going to say, to chime in on that, the reason I kind of teed it up originally too is because just making sure that you guys are advising your clients that this stuff still shows up on background checks. It just says that dismissed. Because I know a lot under the misconception that like it's just gone completely off their background. So they can say I have totally clean background. And so I always advise them, because a lot of HR professionals, unfortunately, don't always know what the dismissed part means or recognize that. And so that's why I tell them to like be kind of prepared, right? That you're aware of what's on your background, so you are prepared to talk about it if that comes up. And then you kind of have your plan statement to say, you know, I was convicted. However, when I went through, you know, the court before a judge, it was dismissed. So we can leave it all the other details, but I kind of use them that narrative to talk to when they're going for interviews and stuff. And so then that way they can at least acknowledge it, but then they acknowledge that it was dismissed. And so it should make them eligible for employment. Any other questions? And then Bryan, too, if you have any other info on those other laws about the misdemeanor getting wiped or anything like that, if you have any info on that, that'd be great to share too.
Well, from what I've read, the misdemeanors, it's automatic. I mean, it's nothing we have to do. The Attorney General's required to go through every year and make a determination of who's at least with regard to arrests, who's eligible for that, and they're supposed to do it on their own. The other, basically, I would advise your clients and if there's any question as to their criminal history that they want cleared, we do any and all. We do misdemeanors, felonies, we seal arrest records. Basically, what I was talking about earlier, if you were arrested and there was no disposition, you're entitled to have that erased and it will be pulled from your record. So if there's any relief that they're concerned about, we can help.
So I have a question for Bryan. Besides the, what was it, the 1203, is 731 also will not allow you to get your gun rights restored as well? No,
it won't. If it falls under the same area as all the 1203.4 relief. So the 1203.4, 1203.41. It does not restore gun rights. Okay. The only way you get gun rights restored from a felony conviction is if the charge was what we call a wobbler, which means it could have been charged as a misdemeanor or a felony. It was charged as a felony. The relief we request, along with dismissal of the charges, would be what's something called a 17B motion, which is a motion to reduce a felony to a misdemeanor. And if charge wobbles, and there are a lot of charges that wobble, like receiving stolen property, vehicle theft, burglary, commercial burglary. Offenses like that do wobble. And if you're able to get that charge reduced from a felony to a misdemeanor, it's considered a misdemeanor for all purposes, and therefore your gun rights are restored because you don't have that felony conviction. Okay, well, I'll reach out to your office because I have some questions in regards to that. And then another question
Well, more like a recommendation or a suggestion, because this is going to cause a lot of confusion as far as like what's going to be expunged, what's actually going to be sealed, and what's still are going to be able to be accessed. So maybe having like a workshop or maybe a website with questions that would be able to be answered, since we're just going to go into effect as of July of this year. There is a lot of clients that are going to be interested in that program, but there are going to be a lot of questions that I'm still very unclear on. So maybe having a workshop or somewhere that they can go with all of this correct information would be very helpful.
Yeah, and we're going to do that with our website. We're going to get the frequently asked questions and things like that. The problem is, until this becomes, we start working with this in the courts, we're not going to know exactly how it pans out and how automatic this is, and how often this relief is going to be granted. I mean, I'm expecting it to work just like our motions now, and except the eligibility is wider. But it may be even easier than I'm making it out to be. It may be that this is handled in chambers, and if you check all the boxes, the judge doesn't even have to have a hearing. But we don't know yet.
Thank you, Brian. I appreciate it.
No problem.
And Chelsea, just to tee up, I know, well, I was going to get to this later too, but to tee up, I know they'll probably have workshops and other organizations will as well. But the Public Defender's Office, they're on site at our resource fair next Wednesday. So they do set up, they bring a whole team and their computers and stuff. So it's a great place to actually go and talk to them face to face for your clients if they have questions and stuff. So they're there every year. It's a great resource, and they can get those questions answered. So Brian, I have another question to you for those that may not be aware. So what is the eligibility for the Public Defender's Office to represent somebody? And then if they are not covered by Public Defender's Office, where would you recommend them go to get this assistance?
I'm not certain what the cutoff is as to whether or not somebody's eligible for our services, especially with regard to reentry. This is the one area where we self-appoint. Usually we're appointed by the judge in court, and they make a determination of who's eligible and who's not. I don't think it's even within our purview to say, no, you don't qualify for us. But I can tell you, I don't think we've turned anyone away, at least from New Leaf Services, to get our representation. So I would send any and everybody. If they didn't want to deal with the Public Defender's Office, I would go to the State Bar website and look for
Oh, you got muted. You got muted, Brian.
or you can do it on your own. You can file what's called a CR 180, and that's the form that you do. It wouldn't include the motion, but it would be a petition, and it's very self-explanatory how you fill that out. You just go to the forms in any jurisdiction, and in Orange County, it's the CR 180, and that is the form you use to apply for relief under 1203.4, 1203.41, 1203.42, and you submit it and you file it with the clerk in the court. They make sure you get it filed to the DA's office, who's basically going to be the one, if anybody, who opposes this, and they'll give you a court date. And there is a filing fee, but there's also a fee waiver you can ask for, and most of our clients get that, and they waive that $150 filing fee.
And did you know what the qualifications are for the fee waiver?
No, I don't know what the cutoff is for that. It's basically, you just fill out, it's like an itemized report of your income and your expenses. And I think if your threshold is under 2,500 a month, you're in. But I don't know, it's not for us to make that determination.
just for everybody from like my own experience sending people, I usually recommend sending your clients anyways, filling out the application, and then the PD office can kind of sort it out from there. They've always been extremely helpful too if they haven't been able to serve somebody for one reason or another, which I think the only like small handful of times it was due to like income, because again, how much they were making. But we found alternate resources in the community as well. So I definitely recommend to try there first and then kind of see from there for your clients. Well, great. Any other final questions for Bryan? If not, we can just turn it over and to announcements. I know another couple of people kind of came in. So if anybody else wanted to introduce themselves or share their resources as well. And if not, thank you so much, Bryan. This is great information. We truly appreciate you coming, especially last minute also, and sharing. And I'm sure as more information comes out, we'll continue to update, the community. On your end, Bryan, if anything comes out, feel free to send it to me or keep me informed so we can spread it out to the larger community as well.
Sounds good.
And hopefully get some people, get stuff cleared.
Absolutely. Let's go.
Exactly. I love it.
All right. Thank you for having me.